I want to welcome everyone to today's webinar on legal problems in investment crowdfunding, brought to you by the Crowdfunding Professional Association. My name is Peter Rostovsky. I'm CEO and co-founder of Raiseway, and I'm honored to be your host for this discussion. The background is that navigating legal compliance is one of the greatest challenges for entrepreneurs that are crowdfunding, and helping the business owner to go through this is what this discussion is about. There are many landmines to avoid while preparing and running and following up on a crowdfunding campaign in order to stay on the good side of SEC and investors. And this discussion hopefully will center around the do's and don'ts of marketing and PR before and during the campaign, the guidance on the investment crowdfunding terms, legal structures for the investment documents. And with us today, we have a panel of prominent securities attorneys who specialize in investment crowdfunding. To start, we have Comi Lefay, counsel at KBA Roche.
That's how it's pronounced. That's how it's pronounced. Hello, everyone. That's right. My name is Comi Lefay. It's pronounced KBL Roche because it's a transatlantic law firm. We are based in New York, Paris, and Germany, which was a very good fit for me, you got to admit.
Nice. I sent you actually a voice message on Instagram asking for please tell me how to say this right.
Oh,
and, it's okay.
I turn off my phone for, yeah.
That's reasonable. That's a good practice.
Thank you.
And we also have with us Andrew Stevenson, partner at CrowdCheck Law. Andrew is a leader in this industry, and I've had the pleasure of speaking with him many times. Andrew, let me give the floor to you.
Oh, sure. Just to kind of keep this quick. Yeah. So, yeah, happy to be joining the panel. And let's say, yeah, in our we've definitely seen a lot of issues that come up, and so happy to discuss and kind of shed light on some of the big ones that companies face when they start doing go down the road of doing an offering under Reg CF.
Thank you for being here, Andrew. And we also may be joined by Jenny Casson, attorney and capital raising coach and founder of Casson Group and secretary of CFPA. But hopefully, if she joins, she'll be able to tell us about her work. But just to set the tone here, our aim is to go through the common mistakes businesses make while preparing and executing their campaigns, and the best practices to help avoid them. Without further ado, let's get into it. What I would love to ask you guys, and Comi, let's start with you. Before launching a crowdfunding campaign, what are your thoughts on choosing between LLC and a C Corp business structures? Do jurisdictions matter when it comes to raising money from different places? What can you share?
Yeah. Thank you very much for having me. I think that, if your company is an LLC because your CPA said there should be an LLC, or, if really a tax motivated decision has been made to find the right form for your business, then technically you should be able to crowdfund, meaning that both are possible. An LLC, a corporation can issue in reliance on Reg CF. In case of equity, the corporation is going to issue shares of stock. The LLC is presumably going to issue, membership units, and everything is going to be fine. Now, what issuers wants to be mindful of is that LLCs, they have to issue every year a K1 form to each of their investors. That can be quite a manual process. So it has been in the past a reason why many investors said, you know what, I want to rely on Reg CF, have potentially a great number of investors. A C Corp seems to be the right fit.
Mm-hmm. Andrew, what do you think?
Yeah, no, there's a lot of business decisions that will go into it. As Comi mentioned, there's important tax implications for changing from an LLC to a C Corp. And so the right fit may may depend on sort of the business interests of the and finance interests of the company. But it's also important that using an offering under Reg CF will introduce will require a company to introduce greater sophistication to its operations than at an earlier stage of its development. And so it likely formed under an LLC, but if it just formed under an LLC for convenience, then a conversion to a C Corp is likely to be the better choice before bringing on outside investors. There's much more structure, much more to a C corporation in the way that the relationship between stockholders and the company that's provided by provided by state statutes and court decisions, rather than relying on the terms of an operating agreement if the company continues to operate under an LLC. We've definitely seen instances of a company, they formed as just simple LLC. They started just one person. So of course it's going to be just a member managed LLC, simple LLC. Then they went and sold securities under Reg CF, and to all those investors became members as well. And now all those investors technically had day-to-day governance rights in the company because they didn't evaluate what it meant to become what it meant for their operating agreement to be member managed. And so those are just sort of some of the examples of kind of pitfalls that can occur just by increasing that that sophistication of in the operations when going into the Reg CF.
Yeah, that feels like a landmine. Like suddenly you have like 100 people who can tell you what to do. All right, that's really interesting. Jenny, thank you for making it. Really glad to see you. We did like I mentioned your work as a capital raising coach and attorney. We just answered a question on what is the kind of the difference between LLC and C Corp for crowdfunding businesses. I want to jump to the next question, and it's tangential. When it comes to prepping a crowdfunding campaign, a business, generally speaking, from my experience of working with Kome, needs to do like a corporate cleanup. So there needs to be kind of well, in our experience, some board resolutions. There needed to be some stuff done before we can reasonably go out to the market and say that we are in full compliance. Jenny, Andrew, Kome, whoever wants to go first, I'd love to hear your thoughts on what that entails, what businesses should think about and work with their lawyers on before launching the campaign.
So even before you get to that point of figuring out, what is it you're offering to investors, you do want to make sure your entity is in good shape, all your filings are up to date, your taxes are up to date. And if you are going to do crowdfunding, you do want to, have a board resolution or a manager resolution talking about the fact that you're planning to do that. Make sure you get that approved. And also, if you've done past securities issuances, you want to make sure those were properly documented and that you did the proper filings for that. So many businesses do, maybe even just issuances of founder stock, and they don't do any securities filings for that, which in some cases it's fine, but in some states it's not. For example, in California, if you have a corporation and you issue founder stock, you have to do a state filing for that. And many people don't even know that. So those are some of the things you would want to make sure you have in place.
And would a SAFE be considered a security issuance?
Yeah, for sure.
Mm-hmm. Okay, thank you. Gentlemen, what do you think?
The definition of a security is any document that promises some kind of financial return through the efforts of others, so whether it's a SAFE, whether it's equity, whether it's debt, those are all securities issuances, and you have to do securities filings.
It is a fair question, though. It is a fair question because we often hear, from a founder, you issued securities in the past, and they say, no, it was just a SAFE. Like,
yeah,
great.
Yeah,
it's a classic.
That's why kind of in our whenever we start working with a company to when they're getting ready for a Reg CF offering, and part of and the first thing is always a due diligence review. What have they actually done? What do they have on record? And we can kind of see sort of the difference between what they think they've done and what they've actually documented. And it's getting that corporate house in order is essential, because it gets a lot harder once you have outside investors. Even if those investors, even if the offering is structured that those investors don't have voting rights, there's a lot more obligations that have to be that come along with having those investors on the cap table. And so it's always easier to get it done, get it cleaned up prior to the launch of the offering.
Thank you. Yeah. So, and in general, how long do you think this process of, what's the shortest time frame in which a company that is in good legal standing, right? They're not like canceled by their state or something. How long should this process take to kind of put a bow on it and say you're ready?
Yeah. No, I saw a company that needed very little work because they were reading blogs about securities law, and because they were reading, many things about, the resources that crowdfunding portals publish, also about corporate compliance. And they talk to other people who are raised under XCF before they even, initiate their own campaign. So that's the best way to get ready, to read a lot about the law.
Right. Become a lawyer, then crowdfund.
Well, no, it's because what is essentially going to happen is you're ready for your XCF campaign. When you start up, attorney says you're ready. And sometimes it's going to take, a day of, just making sure, that the board resolutions are good, that the management team has been identified properly and appointed, that you have directors that have been elected, by the shareholders, that these directors have elected officers in a corporation. All those steps, you want to make sure that they're documented.
Mm-hmm. Yeah, it's definitely gonna be, it's definitely specific. The timing of that is definitely gonna be, so it's company specific. Have they been keeping those records, or have they just been flying by the seat of their pants? Which is normal. I mean, it's, if you're just starting a business, you've got to be out there. You've got to be focused on achieving the value of the business. And if you're a small team, those corporate governance activities, they can slip. We see that in a lot of cases, and it's not anything that is done nefariously. It just happens. But it just needs to be cleaned up and put together and put in order before really moving forward towards launch.
And okay, so let's move forward to the next question, right? So let's suppose that you've come to the lawyer, you've worked with them, and the lawyer says that you're good to go. Great. When it comes to the selection, so I think this is a married question to the terms of the deal and to like what your business actually is and how much money you're trying to raise and what instrument you want to use. But when it comes to funding portal selection, what do you see as some legal implications in that? What can be important for a founder in that situation?
Generally, the funding portal selection isn't going to be a legal question. It's going to be more of a business question of, does this portal have the reach that the company needs to increase its chances of success? I mean, for any portal, even the big ones, I mean, the marketing needs to be driven by the company itself. Some of the big portals, you do get a little bit of foot traffic, but for the most part, it's the company getting to its network and then expanding from there. And so smaller portals can help with that as well. But speaking on, I think on the legal side, though, I know we've cautioned against using some portals that force issuers into structures that aren't necessarily that have not been sort of sanctioned by the SEC and FINRA. Jenny mentioned this over email, and we've seen it as well. So kind of WeFunder has this SPV structure that they force companies into, and it's unclear what would happen if we know that FINRA does not allow new portals to use that same structure. and it's unclear what would happen to an issuer that has that on the structure. Would there be a time in the future they'd be forced to unwind that? So that is one legal consideration, but for the most part, it's really going to be business.
Yeah, this is this one is important, right? This is I've heard about the WeFunder question. I've heard about this various structures and I guess you want to call them brand specific safes being used by specific portals. Yeah, if you guys would share more, I would appreciate that.
One issue that I've seen is many of the platforms that are really aspiring to be high growth companies, they're trying to take a highly regulated activity that should never be done in a cookie cutter way and turn it into something that they're claiming can be done very quickly using, off the shelf documents, filling out just fill out this form. It'll take you, half an hour and now you have your Form C. Well, gee, that's interesting because the SEC says it takes 60 hours to complete the Form C, And so those of us who are lawyers, we've had our experiences where we've tried to help our clients be on certain portals, and certain portals are outwardly hostile to working with attorneys that don't agree with them on how things are supposed to be done. So the question for the issuer is, do you want to do it fast and cheap, or do you want to do it correctly? And if you want to do it correctly, there are some portals that aren't really friendly to you taking the time working with a lawyer and making sure it's done really correctly. And some portals have even been fined for their playing fast and loose with the regs. So it worries me a lot. I mean, there could be a lot of kind of thing, and the SEC is slow. I mean, we're seeing them crack down on some crypto things that happened several years ago. So you might think you're in the clear now because oh yeah, I did a raise on WeFunder and I raised all this money and everything's great. That doesn't mean that 3 years from now, the SEC isn't going to come back and say, oh my God, you did this completely wrong. It's totally out of compliance. So I think you want to choose portals that care more about doing things right than just trying to scale at any cost.
That's really useful. Thank you, Jenny. What do you think in that process, right? So SEC says that it takes 60 hours. Some portals say it takes 30 minutes. Frankly, it's something that on the side of the company that I'm building, we think about, well, okay, how do we speed up the process? How do we make sure, but at the same time, how do we make sure that people that use our tool are in compliance? So what are the places within Form C that, or maybe some other part of this process that are these high risk areas, big alert type of place, right? What can you share?
I think that the starting point should really be the cap table, especially the section of the Form C that is, capitalization and ownership. The action of the SEC obviously is not the same as a few years ago when crowdfunding was very, very new. So if you check on Edgar, if you check old Form C, you're gonna see, documents that are sometimes very concerning. The quality of those documents has increased because you can tell that crowdfunding portals know that the SEC is hiring more attorneys, right? But you still see major issues around ownership, and with sometimes discrepancies between what the founders believe the company issued and what the company effectively issued and what the supporting document says, right? So you need to be careful with who owns what. That would be my first concern, right? Because that's a concern of investors.
Yeah. Thank you, Komi. Andrew, what do you think?
Yeah, I think between the three of us, we can make an argument for every single part of the Form C and why it's relevant and important. But just one thing also note, one thing I see that is kind of in a sort is often in a woeful state for most companies are the risk factors. And the risk factors are, I think a lot of companies don't realize the risk factors are there to protect them. They're there to provide sort of full information to investors about the potential risks of the investment. And a lot of companies, it's like, those like, oh, I don't really want to say that. Can we just use the boilerplate? Well, the boilerplate doesn't add anything. There's no value to that. There's no protection to the company from that. It doesn't give any new information to the investor that other than, hey, we're subject to the same forces as all other companies in the market. Great. That means nothing. Why is it like, sort of, are you a business that is particularly susceptible to changes in consumer spending patterns? Are you particularly subject to changes in supply chain supply chain difficulties? Those are the things that need to be added to risk factors, because that actually informs investors about the potential risks of the offering and gives them what they need to make an informed investment decision. And only once they've made an informed investment decision can the company feel safe that they are not subject, they would not be subject to liability if the investor chooses to challenge their disclosures.
Yeah, and it's also like from the perspective of, you know, you're trying to raise money from these people, it benefits you to be just like, to open your guts really, and not, you know, dilly-dally with it.
Yeah, I mean, honesty goes a long ways, and investors see that.
Yeah.
There's another issue that I've seen come up that it's not exactly a Form C issue, but it's kind of like a very basic issue that people are missing, and that is whether there's a co-issuer. So a lot of people are kind of setting up special entities to be able to raise in crowdfunding. For example, let's say I have a company in another country and I really want to raise from US investors under regulation crowdfunding. So I set up like a US shell company, but really all the activity of my company is in another country. You can't do that because, or for example, a lot of people are raising money for general partners of funds, and they're saying, oh, well, I can do that because the general partner is not itself a fund. But if the activity that, if the returns to investors are dependent on the activities of another related company, really that's going to probably be considered a co-issuer. So a lot of people are raising money with regulation crowdfunding, not taking into account that there's some other entity that should also be completing the Form C and maybe isn't even eligible to raise under Reg CF because they're not a US company or because they're an investment company.
So I want to stay on that for just a second, Jenny. I currently reside in Turkey. I speak to a lot of startups. There is a huge startup community where I am. And it's a prominent question. It shows up all the time. Hey, like I talk to people about crowdfunding and say, oh, that's great. Can I raise money for my startup this way? And this is the question that I wasn't actually sure about. Now, if I have a company that is registered in Kazakhstan, and I discover crowdfunding, I have a huge community that supports me. Let's hope that this community is at least somewhat US based. Can I transfer my operations by opening a company, a C Corp in Delaware? And what would constitute the transfer of operations? Would that mean that I close the business in Kazakhstan and, you know, move my bank account over to the US? What does that mean?
Yeah, I mean, you don't have to close the non-US business, but to the extent that the issuer that is listing on a crowdfunding platform to raise money, if most of its success is based on its relationship to some other business, you know, so like if the main activities are still happening in the Kazakhstan entity, and then it's just like sending some money over to the US entity based on its success, right, then really you've just created kind of this shell company where the investors are benefiting from the activities of the Kazakhstan entity, not the US entity. So, you know, there's nothing wrong with having related entities in other countries, but you have to make sure that the company that's listing on the platform has its own activities that are generating, you know, profits, revenue, et cetera. And that's the main thing that drives whether investors get paid or not.
Mm-hmm. Thank you. Thank you. That's very insightful. Now, let's suppose that we are in this preparation stage of the crowdfunding effort, right? We filled out the Form C, we filled out the risks, we're correct on the cap table information, and none of this shell company nonsense is happening. The next step is accounting. You need to write, or does that come before? Do you do accounting before?
Accounting's gonna need, accounting's gonna need to come earlier.
Yeah.
The accounting process, and there are two aspects of that. First, you have the internal books. The company needs to make sure they have their internal books in order. Have they been doing cash accounting up to now? Well, you got to change that over to accrual. So getting the books prepared in a way that they are going to be under generally accepted accounting procedures, and then that's when the independent accountant will be able to take over for the review or the audit. So that process does take time, and that is something that needs to be an initial consideration for any company going down this route. Probably so at the same time as engaging with portal or legal services, it's gonna want to have engagement with accountants.
Mm-hmm. And if I remember correctly, under $124,000, you do not need to get an accountant review. Like, what's the deal with that situation?
Right. So it's raising up to so that threshold 124,000 for the current offering and all aggregated with any offerings in the previous 12 months. If it's less than 124,000. Then the issuer does not need an accountant to review or audit the financial statements. Those financial statements still need to be prepared in accordance with generally accepted accounting principles. So there still needs to be a balance sheet, an income statement, statement of stockholders' equity, statement of cash flows, and notes to those financial statements. And then the CEO is going to need to certify that those financial statements are complete and correct. And so that's still a lift. It's still going to still be a lift for a company, because you can't pull somebody else's financial statements off the shelf and use them as yours. We've seen people try to do that. It doesn't work. And so so it still takes effort even without that outside review or audit. And for a lot of companies, if they're going to go down this path, as we've talked about, the need of kind of keeping your corporate house in order, I mean, a review is going to be worth it, and it can sort of really help the company kind of understand what it needs to do to maintain accurate books and records. It won't that it'll need going forward now with those investors on its cap table.
Right. Because to remind any founder out there, the punishment for wrongdoing here is what is the punishment? What is the punishment for potentially misrepresenting your information on the on Form C or in the filings?
Well, I think it's not just the securities fraud, potential for securities fraud. It's also going to be the potential for kind of just investor lawsuits under state law. They say that the management and the directors have not undertaken their obligations that they are required to. They have not, and so again, when everything's going great, nobody's going to file a lawsuit. But if things start to go downhill for the company, and what has to do, it's going to go into bankruptcy because it needs to restructure, or just wind up. That's sort of when some of this comes into play, where it's now because those stockholders. So typically, stockholders are going to come after creditors. But if the company has just not done its job during the Reg CF offering, during the governance of the company, and accurate reporting to stockholders along the way, those stockholders may have a claim that actually turns them into creditors, and now you have this ongoing legal fight that they just can't get out of, and that's not a way to run a company.
And what's even a little worse than that is if you, to the extent you don't do things right, you really can't raise money again, because first of all, you have to disclose that as a risk factor And so no one's going to want to invest. And second of all, you aren't eligible to raise again under Reg CF if you didn't do it right. So, even if all your investors are happy, if you ever want to raise again, you have to put in your risk factors. By the way, we violated securities law in the past, and guess what? A lot of investors aren't going to want to invest then.
Yikes. All right, for posterity, everybody knows this now. I want to jump to testing the waters. So you've prepped all that, or maybe when does testing the waters happen? When can you actually go out there and say, hey, I'm testing the waters. Tell me if you like my company. Komi, you want to take that?
Well, we could, because the rule have changed. Well, before, essentially, before 2021, the only way to talk about your offering itself was a very counterintuitive rule called the tombstone notice, where either you were talking about just the company, or you were talking about the offering, and then you had to be super specific about data points that was listed under I believe rule 204. I believe it was 204. Anyway, so those rules were all very complex, and you could only talk about your offering under XCF after the filing of the Form C. So essentially, what changes now is that rule 206, I believe, permits to test the water before before Edgar receives your Form C. The caveat, obviously, is that when you talk about what you're going to do under XCF, you have to specify that no money is being solicited, that if prospective investors want to invest, the money will be refunded, things like that, other disclosures. So that's how testing the water works. That's checking who's going to be interested prior to the offering launch.
So do I have to, let's say that I'm a founder of a company that wants to potentially use investment crowdfunding.
Yeah.
At what point am I allowed, provided that I put the disclaimer at the top of my posts, at what point am I allowed to go on LinkedIn and scream into everybody's ear that please give me money?
You can
without
don't.
You can do it at any time, but the thing is that's really scary is that the rules say that if you publicly solicit investors, then never again, except under some very unusual circumstances, can you solicit them in a private offering. So you want to be really careful about publicly testing the waters. If, let's say you're kind of not sure, I may do a Reg CF or I may do a private offering. Don't publicly solicit, because the minute you publicly solicit, everyone who sees that, you really can't invite them into a private offering unless somehow you end up becoming really good friends with them and develop a relationship and then later make the offering.
So you make a post on LinkedIn, you put the disclaimer up there, you say that I'm, testing the waters, I'm not soliciting anything. And yet you won't be able to solicit capital from them when you go live?
You can, but if you change your mind and say, you know what, I don't want to do a Reg CF, I want to do a private offering of securities under, let's say, like Rule 506B, you can't solicit any of the people who saw that public announcement.
Mm-hmm.
So you might say from that LinkedIn post, you might generate a list of like, these 20 people all expressed interest. Guess what? None of those people can invest in your private offering or cannot be solicited to invest in your private offering.
Unless you develop a personal relationship with them.
And you can't do that for the purpose of asking them to invest. It's just a coincidence that I want to be friends with you. And maybe in a few months, I might ask you to invest in something.
Right. That's a huge question, right?
Yeah.
Yeah.
So that's one of the things. I actually wrote a letter to the SEC asking them to put a time limit on that, but there's no time limit. Anyone who is publicly solicited to invest in your company can never be solicited for a private offering ever. unless you develop a relationship with them.
Interesting.
Scary.
All right. Yeah.
But,
Jeez.
The good news
Walking on a
being,
minefield.
the good news being that ultimately you want to rely on the funding of accredited investors, hopefully. So knock on wood, that's not too bad.
Right. Then you could do a Rule 506C, which does allow
Yeah.
public solicitation. So that would be a solution to that problem. Yeah.
If you have the network, if you have the network of the broker dealer, yes, that's a solution.
Yeah, but if the company is still kind of moving forward with that Reg CF, one thing to kind of, it's really going to still want to take time and think through and carefully consider what it puts out in those testing the waters posts. Those testing the waters posts do get filed with the Form C. They are subject to the anti-fraud rules, and so and those are the kinds of things that if they're trying to do that, so before really kind of getting into a more disciplined way of communicating about a upcoming offering, why not start? That's the time where sort of optimistic founders are using the to the moon emojis and sort of and things like that. That's we now have enforcement actions in cases which say those emojis are misleading, and so that's the kind of thing that it still needs to be, that testing law still needs to be done in a disciplined fashion in order to not trip up the future offering. Regardless of what direction the company wants to go in the future, those posts are still going to be subject to anti-fraud rules. And also the anti-fraud also includes the omissions that are needed to make information not misleading. And so it can sometimes be tricky to correct after the fact. So if we talk about we've doubled our revenue over the last few years. That's great. Well, did it take you 8 times the expenses to get there? That's not great. But not having that full context makes that statement misleading. And now that's going to carry through for the entire Reg CF offering.
This is I would love to ask so many more questions on this subject. But we are about 2 minutes away from being at the time cap. So I think this is, if you have any other comments about the about what precedes the stage of the campaign when you're clicking the button and you're running the campaign, would you please share what you think?
Carefully decide what you want to offer to investors. Don't use an off-the-shelf document.
And to say, there's no free money over the internet. It takes effort and to do it right, and that's what's going to be important for the company over the long term.
Crowdfunding is marketing. Find a marketer if you don't have someone in-house that is extremely tech savvy.
This has been fantastic. Thank you so much for coming. And to all of the listeners, thank you for listening, and please follow up with questions to myself or any of the panelists. As you can see, they are fantastic experts. Thank you. And I think on this fine note, we can call it a day.